Hello and welcome to today's webinar, Health Apps and Data Security. So how to process health data GDPR compliant. My name is Lisa Hofmann. I'm the Chief of Legal Operations here at PrideAged and Certified Data Protection Officer. I'm very happy to have Charles Maddy-Trevitt here with me today. He is our UK market specialist with a huge background in data protection in international markets and various industries. So welcome, Charlie.
Thank you. Happy to be here.
Happy to have you here. And if you have any questions during the webinar, please fill them in the question part of the GoToWebinar box. It should be down to the right, or afterwards send us an email. We have the email address here, and we will try to answer them all at the end of the webinar. So health apps are booming, we all know this, and especially in times like today, with the whole COVID-19 pandemic, this leads to an even faster growth of health apps and the health app market. So we have a lot of customers from the health industry and customers who developed apps, especially because of the COVID-19 pandemic. But also besides that, we all seen that health industry made a huge step towards digitalization in the past years. So during the COVID times, people did not want to go to the doctor, for example, in a waiting room full of people. So solutions needed to be found. So things like health monitoring, therapy, or even making a diagnosis from afar and much more can be already solved with an app today. So as the GDPR categorizes data relating to people's health as especially sensitive, today we want to speak about all the necessary measures in order to process this data safe and also correctly. So yeah, now in the next step, Charlie will speak a bit about the data protection regulations applicable to health apps.
Okay, so in the UK, there are a number of legal frameworks and regulations that cover how patient data must be looked after and processed. The Charter of Fundamental Rights provides basic rights to individuals, such as the right to protection of data, referring to themselves, that it must be processed fairly for a specific purpose and with the appropriate consent. There'll be some more on that later, or for any other legitimate basis. And finally, that everyone has the right of access and to amend their data. And for the UK specifically, the legal frameworks covering how patient data must be looked after and processed are under the DPA 2018, which is in line with EU GDPR. The data protection legislation requires that the collection and processing of personal data is fair, lawful, and transparent. This means there must always be a valid lawful basis for the collection and processing as defined under the legislation, and requirements of the CLDC must also be met. So under GDPR, for recording and processing health and care data, both of the following must be satisfied. 1, an Article 6 condition for personal data, and 2, an Article 9 condition for health data as a special category. Again, more on this later. To meet the common law duty on confidentiality, or CLDC, there are a number of conditions that must be met. They're as follows: a mandatory legal requirement, such as the Children's Act 1989, that allows the CLDC to be put aside, a court order, where the judge has ordered that specific and relevant information must be provided and to whom, overriding public interest, explicit or implied consent, or legal support for the use of confidential patient information without consent under the Health Services Regulation Act 2002 under Section 251 of the NHS Act 2006. The purpose of the NHS Act is to protect and promote the interests of patients and the public, while also making sure that confidential patient information can be used when it is appropriate for purposes beyond individual care. This would generally only be granted when an organization requesting the data makes the case that it would be very difficult or impractical to seek consent from every individual whose data they wish to use. Now we're going to transition to the next slide and look into what health apps are and provide a few examples. Okay, what do we got here? Health apps are application programs that offer health-related services for smartphones, tablets, PCs, all types of communication devices you can think of. It's important to note that these are more consumer-facing products dealing with data, and there's been a drastic increase in strictly medical apps over the past few years as technology and the associated security has developed and become much more approachable. Examples of popular wellness apps include sports, fitness activity tracking, diet and nutrition, even things like weight loss coaching. In terms of pure medical uses, think booking appointments with local NHS surgeries, medical advisory apps, pharmacy access, or, as Lisa mentioned, the massive increase in COVID-related services that have sprung up over the past months. Naturally, these apps collect a lot of personal and very sensitive information. The principles of data protection by design and default are essential here and will be covered later by Lisa, but now it's time to move on to the nitty-gritty and get into proactive accountability and the relevant legal basis for processing data found in these examples.
Exactly. So first, let's speak about the different legal bases which can be used in order to process the personal data. Health data falls under the category of data requiring special protection. So the processing of health data is per se prohibited, according to Article 9, Section 1 GDPR, Charlie spoke already about. But of course, there are certain exceptions which allow the processing of the data. So firstly, we have consent, about which I will go more into detail in the next slide, as it is really important. This is why we have the focus on the consent and we go really into detail here. And it is also very important to obtain the consent legally. But there are a lot of other legal bases. You can see it in the Article 9. There is a long list. But there are two ones which are mainly under discussion regarding the health apps in the health app industry, and two we were asked a lot about. The first one is the preventative healthcare, and the other one is the cross-border threats to health. So we received some questions also from our clients who planned, for example, a contact tracing app for the COVID pandemic, and they wanted to save data, of course, of the people, and asked us if this was possible. So this is a bit tricky here, of course. It's a tricky topic, as it would result in requesting consent. And as mentioned before by Charlie, it's really, to be honest, in an app which should reach a lot of people, very difficult to request consent by each and everyone. But so we were asked if it doesn't fall under the cross-border health threats, as it is a pandemic, and of course it doesn't stop at borders, and it's a global problem. So they asked if they could use this legal basis. But here there is a specific requirement, as you can use this legal basis only on the basis of union or a member state law, which provides a suitable and specific measure to safeguard the rights and freedoms of the data subject. And such a law is unfortunately not in place yet. So at least for the COVID tracing apps, this is not an appropriate legal basis. And then we have the preventative healthcare, and this is more about the treatment contract between a doctor and the patient, or the hospital and the patient. Basically, all the contracts with healthcare professionals. So health apps couldn't rely on this lawful basis neither, and would have to go for consent here as well. And we will speak more about the consent in detail now in the next slide. So we spoke about this topic already of consent already before in a lot of webinars, as it is really important that the data subjects must be given the full information before giving their consent. So the data subject must be informed about, of course, the data controller of the processing. The data controller determines the purpose for which the data is used and the means by which the personal data is processed, of course. So in the case of a health app, it would always be the creator of the app, so the one who gives access to the application. Then you need to be informed about what data will be processed. So for example, such as name, surname, but also especially if you process health data, you have to name what data especially you process and the purpose of the processing of the data. And here you have to be especially aware that the processing has different purposes. And so if the processing has different purposes, you have to get for each purpose the special consent. So if you have one for the operation of the app, you need special consent. Then for the newsletter, you need special consent. Or for statistics, if you want to use the statistics of the app, also here you would require special consent for this. You cannot just go for one in all included. That's unfortunately not possible. And very important as well, that if your purpose changes, if you use the app then in the end for a different purpose, then you have to also get new consent from the users. You cannot rely on old consent. Also, if you had an app already installed before GDPR took place and the consent rules were not that strict, then you still have to now get new consent as well. And furthermore, you have to inform the data subjects whether the data will be shared or processed by or with third parties. This is right now really important, as we spoke in our webinar before already about the Schrems decision, which brings a lot of companies in trouble right now with data transfers to the US. And yeah, so this is troubling for everyone, but the data subjects need to be informed about this, and they need to be informed also about the rights of the data subject, so about their right to withdraw the consent at any time. And here again, important, the withdrawal has to be as easy as giving the consent. So you cannot go for consent like one click check, and then to withdraw the consent, you would have to write a letter, for example. This is unproportionate. And all this information must be also given in an understandable form with a clear language. So sometimes when Charlie and I, for example, have to write consent forms for our clients, we have to maybe let them be double checked by someone else from the team with not a legal background, maybe because just what seems obvious to us, like, oh, this is obviously stated, that's so clear, it's maybe not that obvious for a person who hasn't studied law. So this needs to be like very clear language, plain for everybody, easy to understand. And of course, also the consent, we get asked a lot, like, how can the consent be given? Must it be in writing? It can be in writing or electronically. What is important here in giving the consent is that you have to keep the records to prove you obtained the consent. Because as everyone who has a company can say for sure, is that customers can be complicated sometimes. Customers can be tricky. They can say they never gave consent, even though they did. And this is why you have to keep a record of the consent. And of course, the consent needs to be given voluntarily. So this means you cannot force it, and you also cannot couple it. That's really important as well. So this means you cannot obtain consent for receiving a newsletter, for example, or phone calls even, when it's linked to a contract. So when a condition for the conclusion of the contract is giving the consent for a newsletter, for example, you can only download the app if you accept our newsletter. This consent would generally be invalid. So the prohibition. Yeah.
Sorry to interrupt, Lisa. I'm just seeing here that some people can't see the slides.
Okay.
Do you know if there's any way to bring those in? Because I think the visual aid is quite helpful with these.
Of course, because we have it all written down. I mean, now I switched the slide. Can we get some more feedback if you can, if now it's solved the problem?
All I can see is the let's get started slide.
Okay.
What is being said.
And is this a problem everybody is having? I mean, we stand on the presentation later on, but of course, right now it would be great to have it as well. Charlie, can you see the slides when I'm switching them, or?
Yeah, I can see them.
Or maybe it's stuck. I really, as I will also say later on, I'm not the most technical person here. So,
I guess
okay, someone is saying something about the mobile. I can see them with when I swipe left on my mobile screen. So I can see them. Okay, we got some feedback. I can see them, no problem. Okay, and then let's maybe just continue. Maybe it's a problem of the user, maybe of the internet. I'm really sorry, but again, we will send them all out later on, so no problem at all. You can see them later on. When you registered, you automatically get an email. Oh, but now I'm not sure when I stopped. Yeah, coupling. coupling is prohibited because this also serves the principle of data minimization. So for example, as we spoke about the newsletter is the most common topic. For the newsletter would only be the email address would be required in order to send out the newsletter. So when you, for example, have a registering form in your app and you are requesting also the name and the surname, this would be again not legal because only the email address is really required. So and the other mandatory fields are not permitted as they would not be required for sending out the newsletter. But we will speak about this, about data minimization, also later on in privacy by design and privacy by default. One more point, then I'm finished with the consent topic. If you need the consent of minors for your app, you would need the consent of their legal guardian. So you can, of course, not request the consent itself by a 12-year-old because she would maybe not be capable of it. So you would need the consent of the legal guardian because, of course, also minors should use some health apps. And now, in slide 8, and the next one, Charlie will explain the good practices for companies developing health apps.
Okay, so as you can see, there are a number of good practices that data controllers can take in order to be safe in the knowledge that they have a strong approach when building and developing their health apps. As you can see, these stem from relatively simple messages that every organization should incorporate into their data privacy understanding, such as minimization and anonymization, having simple and approachable privacy policies and legal notices, and also noting their processing activities down. Impact assessments are also extremely important when dealing with this type of sensitive data, as they're a key part of your accountability obligations under the GDPR. And when done properly, they help you to assess and demonstrate how you comply with all of your data obligations. To wrap all of these together, the appointment of a data protection officer, DPO, will ensure there is an individual responsible for these measures. Now, if these are integrated, then it becomes a lot easier, and this is where Lisa will describe the default privacy in the next slide.
Exactly. So yes, now we want to speak a little bit about product-specific data security. So what do you have to pay attention to as a developer of a health application? And here we will talk in detail about privacy by design and privacy by default, as these two terms are much talked about, and you hear them a lot in regards of data security, but only very few know the real meaning and also the real importance of the privacy by design and privacy by default. So privacy by design means that data protection should already be technically integrated during the development of a data processing procedure, for example, a new feature in your app. So data protection in the sense of the GDPR is achieved through the earlier intervention of technical and organizational measures and already at the development stage of this app. So by developing, not afterwards, like not developing the app and afterwards implementing the technical organizational measures. I say that because we have a lot of those companies. Of course, they are young and eager and implement the app, but afterwards they see, we should have maybe here have this firewall, build up this technical organizational measure. So if you build it in from the beginning, it will be also easier for you in the end. So by means of user-friendly presettings, only data that are really necessary for the processing should be collected during the processing. We already touched this point before when we spoke about the consent, and this principle is known as, Charlie also mentioned already, as data minimization. So if a company develops an app in which data is processed, the company must take care during this development, during the development stage, for example, that fields are not absolutely necessary, can be anonymized or pseudonymized. And of course, the company should always think about the data deletion concept as well, so that the data can be deleted easily, that you have like the dates in mind, how long do you have to store the data and how long can you store the data. There are of course legal requirements, and this should be implemented already in, as we said, the development stage, that, for example, after 4 years, this and this data is deleted because we don't need it anymore. Then, speaking about privacy by default, you can understand this concept as data protection through data protection friendly presettings. This means that the factory settings of the app should be created in a privacy friendly way, especially for users who may not be as technically minded as I am, as we saw with the sites. I hope I fixed that. Yeah, so users who are not able to make their own data protection settings in the application in the way they would want them to be. So this is why developers should integrate it correctly into the app. So not that you have to go into a box and deselect something. Right now we also have this a lot with the cookies, that you cannot add them from the beginning on, but you really need to check, I want to have this cookies. Really important, and a cookie webinar already coming up. Spoiler alert. So to summarize, I wanted to say that app developers and providers who want to distribute apps in the UK and also in the European area should be aware of the data protection requirements as early as in the creation and development phase. So things like, what data do I process, on what legal basis do I process the data, and do I need consent, of course. The design, in accordance with data protection law, as well as data protection friendly presettings, should ensure that the app can be offered later without any deficiencies in the GDPR compliance. As I said, we had this a lot before, that the app is already on the market, and later we saw this is maybe not 100% compliant, and it's much more difficult to change it afterwards than when you have it right from the beginning. So for the design, in accordance with the data protection law, you should always clarify this with your data protection officer. If you process health data and this on a regular basis, then you would really need a data protection officer, and always check back with them if you could do those processing procedures. And this brings us also back to the register of processing activities, which Charlie also mentioned earlier. This is really important to have this established, to have this in place, to have a clear overview, and then later, if something changed, you need just to make like a very, very small adjustment instead of changing it like all. So furthermore, the app must contain a privacy policy, and the user must be informed which data should be processed, and the privacy policy should be available in the App Store before downloading the app, so that the potential customers can already see the information before. They can see beforehand what data will be processed and how. So also general terms and conditions, and if you have the terms of use of the application, should also describe the services in detail, so that users can really assess which data is necessary, so that they can see, for example, the app requires like this and this data. I understand they need it for this and this purpose. So just make everything clear, be an open book about it, then you're on the safe side, definitely. And also a system should be, of course, installed to protect the rights of the data subjects, as we mentioned before, like the right of information, the right of deletion, and correction of the personal data. In apps, this can be easily done with a simple form, for example, with a request form. They send it, and then you have, like, for example, for information rights, you have a month to answer that. So with a simple form in your application, it should be easily handled. And it's quite simple, as I said and mentioned many times before, data protection friendly presettings. The app should be preset so that data processing is limited to the data it requires. I repeat it so much because it's a really important point, the data minimization. And of course, data processing may not be started before the consent actually has been given. This is also, I saw this in a lot of health applications. Actually, I downloaded, if it's fitness apps, they may ask for consent, but later on, after the processing already started, then they ask maybe for consent after you've given them already some of your data. So this is wrong as well, and this you should do also before you start processing. Ask for the consent first. So this would be it in regards of privacy by design and by default. And now a bit about specific services for companies in the health sector.
Okay, so here we'll take a quick look at an example of how the requirements can be successfully applied in a real-life company. And we're going to be using a client of ours, Yokeru, to see what was needed and how it was done. So here we go. The company themselves offer a fascinating healthcare automation process, providing a way to better collect data in order to provide the best possible care for vulnerable patients in the UK. Their automation limits contact and vastly reduces time spent gathering information, allowing more time for actual treatment. Clearly, they deal with a variety of sensitive health data, and a lot of it is COVID related. So now Yokeru works with PrideAged to ensure compliance with the European legislation we've mentioned throughout this webinar, and thus they can continue to offer their services throughout the country. Here we can see how PrideAged offers a number of the essential services, such as appointment of an external DPO, as well as important documents like the impact assessment, processing activities, etc., as well as more widespread international services, such as HIPAA compliance, which allows companies like Yokeru to expand and operate their health services in the US, adhering to all appropriate safeguards. Yokeru themselves have benefited greatly from this, with Hector, that you can see on the slide, stating that PrideAged's holistic approach allowed them to be confident in their GDPR and really focus on helping people in need.
Great. Thank you. So let's speak about PrideAged now and how it can help you, especially if you are a health app provider. As we said, we spoke about all this before. What is really important is to detect and identify the risks you have. So maybe you're missing the register processing activities. This needs to be identified. This can be done with our gap analysis. Then we see this and this is missing. But it's not also, of course, if you know what you lack, but then you have to define, of course, measures. You take measures in order, for example, if you have risks, in order to mitigate those risks and to lower those risks. And then what we need is also a program to monitor and implementing those measures, because as I always say, data protection is not a one-time thing. We have a lot of companies, they think they can do it one time and then they are set. But unfortunately, it's not like this. You have to be really up to date here. You have to be up to speed, always controlling, because the law is also constantly changing. Then we have new rulings like the Schrems ruling, which is completely throwing everything over again. So you should really be on track here with the GDPR and how it changes and how the privacy laws are changing in general. So with PrideAged, we have an online platform. We can do all of those things. We can conduct risk assessments. We have like the technical organizational measures you need predefined. You can create privacy reports. We have international data transfers, how you can handle them. You can create your own register of processing activities really easy. So basically everything done and everything in one platform. This is also really nice, because when I was working before internally for some companies, then it's always you have the issue, you maybe have all this information, but it's always laying around like with different people. So the IT has this, a legal department has that, and when it comes to an audit or something by an authority, for example, then you really have to search and to look, where is it? So with PrideAged, you have this all in one platform, which is amazing. And you can, of course, try it. So you can always have a 7-day free trial. Just contact us in the end and we will provide you with that. So now we come to the questions. See here, I have a bit of problem that it goes under all, like the screen is working. Comments. Charlie, could you pick already some?
Yep. What have we got? For what purpose is someone considered a minor? Okay, so the age at which a child can give their own consent under GDPR is 16 years, but That being said, in the UK, that age limit has been lowered to 13 by the Data Protection Act 2018 in that amendment. Yeah.
Okay. I'm good to know. Yeah, in Germany it's 16 as well. So
16 is the kind of recommended, but the member states can then lower it to what they deem to be appropriate. And that was what happened in the UK.
perfect. So then we have the question, what technical and organizational measures do I need to implement for privacy by design by default? Okay, that's a bit a tricky question because, as we always say, it depends a lot on the organization, on the size of the organization, and also on the data you are processing. And also the law here is not very specific, at least not the GDPR. In Article 25, it states only the point of pseudonymization as a concrete measure. But of course, that can't be everything. We know that data minimization, as we said before, is a very big point. And yeah, the technical organizational measures always need to be state of the art. But you always have to balance them out because, like as I said, a small, tiny company with like not a lot of customers cannot have the same technical organizational measures than like a big healthcare provider. And also you have to take into account the nature, the scope, and the circumstances and the purpose of the processing. So there are several suggestions we have also for technical organizational measures, especially in the ISO norms. But of course, again, especially a small startup is almost impossible to comply with all of them, and maybe it's not even necessary because one technical organizational measure is, for example, the prevention of flooding. Maybe you're not in an area where this can even happen, or then you have like a lot of technical organizational measures about servers, the storage of servers, server rooms, but maybe you're not even having your own servers, but you rely on hosting somewhere else. So you have to look at their technical organizational measures. So this is why there is not a list which is the same for each company, but there are different security measures depending, again, a lot on the data you're processing, on your size, and the more data you are processing, the longer you are processing the data, the higher the measures, the higher the restrictions. And but having a list of the technical organizational measures and also implementing them is very important because this is a major data breach and can lead to significant fines if you do not have this in place. So any other questions so far?
There's one here about developing an app where the personal data stays on the patient's phone or tablet, but the company will only have access to the device ID of the phone, whether that's allowed or not. This only allows them to then This only allows you to then send out push notifications to that specific patient, but you will never know their name or address, so would never be able to identify them.
I think this is a question where we should really look closer in the circumstances of the company, because I worked a lot with companies. They said me circumstances like this, that they are not actually processing any sensitive data, any special category of data, because it is belongs still to the hospital, it belongs to someone else. But then as soon as we were digging a little bit deeper, then we saw it is still at some point they are processing the health data, at some point they have access to this data. So it's not always that very easy to say. So please feel free to write us a message in the end with like more detailed description, and then we can also answer the question better, because this is really depending a lot on the circumstances of the company, I would say.
Then we've got someone asking for a recording of the webinar, which I believe will be sent out at the end, correct?
Exactly, like not at the end, like tomorrow. It will be cut by our amazing team, and then we will send it out.
Perfect. And then I think one more came in about the exact security controls that would be recommended for a health app. And I think
that was the one already with the technical organizational measures. That's like, yeah.
dealing with.
Very individual.
Okay.
But if you want to have a look at like some suggestions, at least the ISO 27001 is like the best recommendation here to have a look at it.
Yep.
Okay, then I think we are through. And if we see like more questions, because right now it's a bit tricky because we have like a lot listed up from when the screen was maybe not working. So we will answer them later on, get back in touch with you, and just send you an email, I would say.
Yep.
Perfect. Then thanks everyone for attending, and see you next time.
Thank you.